Hello, I'm Shane Hensman, solicitor in the firm of Hepton Stalls LLP. Deafness has a number of signs. Often clients we find aren't the ones that notice it themselves. Often it's family members that may raise concerns about television volumes or radio volumes being on too high, clients not answering the telephone, and more clients tend to report problems where they themselves are in actual social situations where there's a lot of background noise, and they often find that they can't follow conversations or have to ask people to repeat themselves. Deafness is measured by a simple hearing test, or audiogram as it's known. Hepton Stalls can arrange that for you and send you to an appropriate and experienced audiologist. The results of that will be produced and given to us, and that interpretation of that audiogram will determine whether you actually have a hearing loss claim or not. There are many industries and workplaces that have been noisy in the past and have exposed clients to noise and caused deafness. This can include the car industry, the shipping industry, the military, mills, textiles, steel, coal, anything in reality where you may have struggled to talk to colleagues whilst you were working is likely, or at least could be an indicator of that workplace having been noisy. In normal injury claims you have 3 years to bring a claim. That is no different in an industrial deafness claim. The key question in industrial deafness, however, is how long have you had symptoms for? Those symptoms may come on therefore 5, 10, 15, 20, 30 years after you were last exposed to noise in the workplace. That doesn't mean you can't claim. If you have noticed problems within the last 3 years, you may still actually be able to bring a claim. Bringing a deafness claim generally will take between 1 and 2 years. In cases where things run very smoothly, it can be less than a year. In cases where, for example, the court process needs to be involved, that can take something between 2 and 3 years, but the rough average is between 1 and 2 years. Compensation is determined by the level of your actual hearing loss. Therefore, it's very hard to give an exact amount as what you might receive, as that is determined by the hearing test that you will have. However, generally, damages of between £2,000 and £5,000 are not uncommon. Hepton Stalls have a specialist industrial disease department with a number of fee earners that have worked for the firm for a number of years, and in fact Hepton Stalls itself has handled these cases for a number of years also. There are very few problems that we've not encountered where we've not found solutions, and we handle hundreds if not thousands of claims per month and per year, and have settled millions of pounds worth of compensation, recovered millions of pounds worth of compensation for our clients. Hepton Stalls offer no-win, no-fee arrangements. Alternatively, these are known as conditional fee arrangements. In short, if your matter is successful, which is the case in the majority, we will seek to recover our legal costs on your behalf from the defendant. If your matter is unsuccessful, we won't seek to charge you in any event anyway. This therefore means we can actually offer you a genuine no-win, no-fee service.